Welcome back to another segment of King County Law Library's What to Expect When series. Our returning experts are Rosemarie Lemoyne, local family law attorney, and Lulu Miles, who works with King County Superior Court and manages the Volunteer Settlement Conference Program. Okay, Lulu, so in the previous video, we talked a little bit about what the Volunteer Service Settlement Conference Program is all about, some of the elements there. So let's assume now that I am a person representing myself in a family law case, and I've chosen to use the Volunteer Settlement Conference Service. Walk me through what's next.
So what's next is once I receive the email from either a paralegal, an attorney, or a pro se party, I will send over current available reservations. You'll have to choose a date and agree on the date with the other parties. So for example, if I get an email from a respondent, then the petitioner needs to actually agree on the date. Sometimes it could be a little difficult. I might not hear back from one of the parties, but if they're pro se, I usually send them back to, I believe it's called early resolutions managers, to see if they have space for them. Otherwise, I'll hear from the attorney, paralegal, the parties, set a date, and it's just that easy, that informal. So once they choose a date, I will conduct a confirmation letter receipt, which is a letter that has their information, some instructions, what to look forward with the mediator, which is the settlement conference attorney. And then I kind of pass the torch to them. So once that letter comes out, that's their receipt that their date has been reserved. And then they go on with their date with the mediator.
Okay, great. Thank you. So you mentioned communication and reach back. And I know trying to communicate with the courts these days is really confusing to figure out what you're supposed to do.
Mm-hmm.
Is there any part of this that's online through a program like scheduling programs or anything? Is there anything that's online about this?
I have the website, and so you can reach the website through either family law or more information on they're in two places, but it should be we'll have that within the video, of course, on where to find it, but it's two different places, and it's just the website on what to expect, contact information, that sort of thing. So yeah, that's it. Pretty much sums it up on that website, what to expect, history of the program, that sort of thing.
And will my communications with your office be primarily email?
You can call me. There is a phone number directly to the settlement conference program. I prefer email just so I could see it. It's right in front of me. But my response time is within 24 to 48 hours. But you can always reach me by email, and I respond with whatever request that you may have.
Okay, great.
Mm-hmm.
And so let's say you've actually partnered me up with a volunteer mediator. How do I communicate with them?
So you would communicate once that confirmation letter receipt comes out. It's going to have all their information in there. It's going to have their address just for information purposes because of the pandemic. Pre-pandemic, you were able to actually go into the law firm. But now it's strictly by some type of video conferencing like Zoom, Skype, Microsoft Teams, that sort of thing. And so you would call them from the information that I have in the confirmation letter, email. So all that's provided to the parties.
And that just depends on the way the volunteer mediator chooses to work, correct?
Correct. So right now, mostly all of my panel, they're conducting their mediations through video. I actually need to find out more information if they're going to be coming back, that sort of thing. But for right now, it's by video.
Okay, great. So let's assume that that's all happened. I reached out to you, you've coordinated it and partnered me with a volunteer mediator. So Rosemarie, what do I need to do to get ready for a settlement conference?
Well, when I received the email from Lulu, and thank you for your excellent work, Lulu. It's
thank
wonderful.
you. Thank you so
much
much.
Appreciated.
Thank you.
Because Lulu, many times the lawyers have said we need a settlement conference, and we go to Lulu and she gets us in, and it really saves our case from having to go to trial. We're able to settle, which is always wonderful. But When I receive the notice, I will set up a Zoom conference for the parties and establish separate conference rooms. So pretend we have a husband and wife who are divorcing. Each one will have his or her own conference room and be invited into that room with his or her attorney. One thing important to remember is that when the parties contact me or their attorneys, everything they say to me should be shared with the other party. Nothing should be confidential. But sometimes one of the people involved in the case will be the victim of domestic violence and perhaps not be able to share an address or be afraid of sharing the address. I urge you to contact your mediator privately and let him or her know that. And then they will work around it. It's very important that they know, please do not share this address with the other side or this phone number with the other side. When you're in mediation, everything is confidential. And you cannot, if we don't settle, you're not able to share what the other side offered during that mediation with your trial judge. If we settle, we'll sign a document called a Civil Rule 2A agreement, summarizing the terms of the settlement. But Rick, you asked, what do I do to get ready? What I always appreciate having is just a short email or a letter, it doesn't have to be fancy, that tells me, here are the issues, this is what I want. To know that gives us a guidepost to go by. What is important to you? And then King County Family Law Rule 10 requires that you exchange financial records if maintenance, attorney's fees, child support, and frankly, property is at issue. Those financial records, 6 months of bank statements, 6 months of investment account statements, 2 years of tax returns, your pay stubs for the last 6 months, your 401k plan, your IRAs, last 6 months as well. That's important. And those are really the only documents you have to exchange. When you send them to me, you should also be sending them to the other side, so everything is shared. Now, one thing I would caution, when you send financial records over the email, it's not secure. So ask your mediator, do you have a Dropbox or another link where I can share these materials? If they don't, and they need you to send them over the email, I urge you to black out any account numbers, because certainly you'll share those later, and your opposing party should know those. But be careful about sharing sensitive information like social security numbers and account numbers over email. That's basically what I need from the parties. If parenting is at issue, having your proposed parenting plan is always wonderful. It gives us that roadmap and gives us something to work on during the settlement.
Let's assume that I would like to have a third party, someone who's not the other side and me, attend that settlement conference. Is that possible?
I don't mind when people bring a third party. Some attorneys I know who do mediations do mind, but it depends. I always caution the litigants that if you want to bring a third party, remember that this must be your decision, not the third party's decision about settling. And sometimes I've had third parties take over and do more talking than the litigant. And now that's not the goal here. The goal is to make it your settlement. But I can understand that having your mother there or your friend, that helps sometimes. It makes people feel more comfortable and sometimes more confident. And I'm certainly willing to do that. In some cases, we don't usually see them in this program. People will bring an accountant because the financial issues are fairly complicated. And that's certainly understandable.
Okay. So maybe best advice is to ask your mediator how they prefer to handle that.
Definitely.
Okay. So let's assume that I realized I needed to do the volunteer settlement conference program. I like the idea of not having to pay for that. I've talked with Lulu in her office and have been partnered with a mediator like Rosemary, and Rosemary and the other side and I have all attended a settlement conference hearing, and we all agree. So what is the effect of that agreement on my situation?
If you sign the CR2A agreement, Civil Rule 2A, and that's easy to find, and I'm sure Sean, our wonderful videographer, will give us a link to that. If you sign that agreement, that can be the basis for your final documents, and you don't have to have a trial. That's the beauty of settling. You avoid going to trial, and you get a chance to have a say in what happens.
And it's also true that in King County, in a family law case, I am required to try to mediate in one method or another, and I will not have a trial until that has been attempted, correct?
That is correct, except for cases involving domestic violence.
Mhm.
In cases involving domestic violence, mediation is not mandatory. However, in some of those cases, the victims of domestic violence have said, I would like a mediation, I would like a settlement conference, and it's their decision. So that's something, if you are encountering problems, if the other side is pressuring you and you're the victim of domestic violence, you can certainly file a motion with your assigned trial judge to ask him or her to allow you to opt out of the settlement conference.
Mhm.
Lulu, one more follow-up question. How long does the settlement conference last? Is it supposed to last a certain number of hours? Does the volunteer attorney have to give a certain number of hours?
Good question. So my answer is it's a minimum of 3 hours, and I believe if it goes anywhere after 4 to 5 hours, it's probably best for parties to hire their own mediator, which is of course there's fees involved. But from my recollection, how this program works is a minimum of 3 hours is what we offer here, fee waived.
Thank you, Lulu.
You're welcome.
That's right. When it's a very detailed or complicated case, sometimes you can hire a lawyer or a retired judge for mediation and work with them longer than the 3 hours that you would get from a volunteer attorney. Because Lulu, when they're assigned a volunteer attorney, the folks can't change and say, I don't like the sound of that name, I want a different person, can they?
Correct. Yes. And also, most of my attorneys are on a rotation list. So I don't even get a choice. So of course, I create the rotation at the end of the year, but it's set. So no parties can choose who they want. It's set by date per attorney. So no choices, just what you get. And you guys are all fabulous attorneys, giving your time and volunteering, and over 9+ years, you can't beat it.
Thank you, Lulu. And
Yeah.
I wanted to ask you something. So the lawyers have to have a minimum of 9 years experience?
From what I've been told, and which the master attorneys come in at, but we like to refer to them as settlement conference attorneys or mediators.
Well, I think we've heard a great deal about the Volunteer Settlement Conference Program. It's fantastic to have Rosemary and Lulu here with us as our guest experts. Thank you very much for sharing your expertise.
Thank you for having me, Rick.
And thank you, Rick. The library is fantastic.
Yes, it is. It's a good resource. Yeah.
It's wonderful.
Thank you.
Thank you.
Thank you.
Bye.